students, today we will be dealing with the chapter on transboundary pollution. The objectives under the lesson are to understand the problem of transboundary pollution, to understand the international conventions of transboundary pollution, and to understand the important cases and its impact in the area of transboundary pollution. Now, let us deal with the introduction of the chapter. The evolution of the hazardous waste problem dates back to the advent of civilization. Oil pollution is a phenomena that has rocked the international census for the scope of property damage, including damage to the general environment, which is beyond calculation. The 1968 Santa Barbara, California oil spill accounted for an oil slick covering 400 miles of the Pacific Ocean. The 1967 wreck of the SS Torrey Canyon released more than 35 million gallons of oil along the coasts of England and France, and later resulted in a substantial jury verdict for the victims. In April 1984, Standard Oil Company of Indiana and two subsidiaries that operated an oil tanker that lost control of its rudder and ram aground off the Brittany coast of France in March 1978, causing one of the biggest oil tanker spills in the maritime history. These were held liable for environmental damage that exceeded $2 billion. Nearly 100 claimants representing 76 French communities achieved a single victory when federal court judge Maguire found the defendants negligent with respect for the design and construction of the faulty steering gear. Second chapter will be dealing with the definition of dumping and its international policy. Dumping is defined by the London Convention and the 1982 United Nations Convention on Law of the Sea as the deliberate disposal of waste or other matter at sea. Disposal of hazardous waste, such as by dumping, has created worldwide problems. The export and improper disposal of hazardous waste means that health and environmental problems will be inflicted even for future generations, and animosity between the developed countries and the developing countries of the world. There is the potential for catastrophic environmental and foreign policy implications, with the inevitable backlash to indiscriminate dumping. Multinational corporations are frequently at the root of this problem. Incineration of waste at sea has been treated as dumping and is regulated by the London Convention. Now, let us know about the role of Intergovernmental Maritime Consultative Organization. This organization is a United Nations activity headquartered at London. It has promulgated 3 conventions on oil pollution, namely the International Convention relating to intervention on the high seas in cases of oil pollution casualties, the Intervention Convention and the International Convention on Civil Liability for Oil Pollution Damage, Civil Liability Convention, and the International Convention on the Establishment of International Fund or Compensation for Oil Pollution Damage. Now, we will deal with the treaties, conventions, resolutions and protocols in the area of transboundary pollution. Now, these have emerged from the international community of nations encompassing many aspects of issues associated with hazardous waste disposal. One of the more interesting international agreements balancing the right to explicit one's own environment against the responsibility to do so without damage to the environment of another is the Convention on the Prevention of Maritime Pollution by Dumping of Waste and Other Matters. Marine pollution causing serious damage to another state would be internationally wrongful, and that polluting activities might in some circumstances require consultation with other states likely to be affected. United Nations Convention on the Law of the Sea 1982 affirms customary obligations to protect the environment of other states and avoid abuse of rights. It recognizes a general obligation to protect the marine environment and support the conclusion that the diligent control of land-based sources of marine pollution required by Articles 194, 207 and 213 of the 1982 United Nations Convention on Law of the Sea 1982 constituted a rule of customary international law. The Brussels Resolution on International Cooperation concerning pollutants other than oil 1969. This resolution was adopted at the International Legal Conference on Marine Pollution Damage held under the auspices of the IMCO at Brussels in November 1969. The United Nations Convention on Law of the Sea 1982. This convention establishes a general framework for the regulation of land-based sources of marine pollution. This concern for development priorities is evident in the general provisions of the Article 193, which refers to the sovereign rights of states to exploit their own natural resources pursuant to their environmental policies and in accordance with their duty to protect the marine environment. Article 194, Clause 1 moderates the obligation to protect the environment by reference to the use of the best practicable means at their disposal and in accordance with their capabilities. Articles 122 and 123 of the Convention, which deal with enclosed and semi-enclosed seas, merely reaffirm the general position that states must cooperate in measures of environmental protection. Article 207 of the Convention requires states to take measures including the adoption of laws and regulations to prevent, reduce and control pollution from land-based sources. In 1972, the Stockholm Conference called for an international regime to regulate dumping. It has since been supplemented by regional treaties. The Stockholm Declaration of the United Nations Conference on the Human Environment stated clearly in Principle 21, states have the responsibility to ensure that the activities within their jurisdiction or control do not accuse damage to the environment of other states or of areas beyond the limits of national jurisdiction. This convention has three objectives. First one, to reduce the transboundary movement of the hazardous waste to a minimum consistent with environmentally sound management. To dispose the hazardous waste as loose as possible to the source of generation. To minimize the generation of hazardous waste in terms of quality and their respective hazardness. London Dumping Convention facilitated the development of international policy and making provision for institutional supervision by the international community. This is significant that a resolution of the parties to the London Dumping Convention calls for the United Nations Conference on Environment and Development to consider the creation of a global mechanism to coordinate the protection of the marine environment from all sources. an important modern hazard. Radioactive waste dumping. The need to find a safe medium for disposal of radioactive waste material is one of the more intricate problems of nuclear power. Disposal in Antarctica is forbidden. By disposal or reprocessing on land carries risk for the health of present and future generations. Dumping radioactive waste at sea. Article 25 of the Seas Convention 1958 requires states to take measures to prevent pollution at the high seas from dumping of radioactive material, taking into account standards set by the relevant international organization. It was left to International Atomic Energy Agency to promulgate standards and internationally acceptable regulations. The Basel Convention 1989. This convention on the control of transboundary movements of hazardous waste and their disposal came into existence in the year March 1989. The convention was aimed at primarily being the instrument to monitor the transboundary movements of hazardous waste rather than prevent it. The lack of preventive approach to waste management has led to the generation of more and more hazardous waste, especially in the developed countries of the world. The Basel Convention regulates the export of hazardous waste. It forbids the export of any hazardous or other waste until the importing and transit nations have provided written authority, that is, the importing nation must confirm the existence of a contract with the exporter based upon notification that includes specific information about the nature and amount of the waste generator and the ultimate disposal of the waste. A transit nation is required to respond within 60 days, but there is no time limit for the importing nation's response. Basically, the Basel Convention mandates that no nation shall export to a country that has prohibited imports of particulars. The enforcement of Basel Convention. The importance of enforcement measures is particularly evident in the case of Basel Convention. It obligates states to adopt scientific control measures and sets up a control system which shall be coordinated by the Convention Secretariat. The Convention Secretariat has the function of coordinating and monitoring party states towards each other at international level. Some provisions of the Convention provide a framework for enforcement and delegate the elaboration of concrete measures to party states at the national level. It is very important to know about the important cases relating to transboundary pollution, which we will deal under the chapter of judicial activism. The landmark cases: Trial Smelter Case, Arbitral Tribunal Number 3, UN, Reporter International Arbitral Awards, 1905-1941. In 1953, Trial Smelter, a metal refinery in British Columbia, was found to have discharged sulfurous gases that damaged farm crops across the border in the state of Washington. Mainly on evidence presented by the International Joint Commission, an international tribunal comprised of an American, a Canadian and a Belgian found the Canadian government liable for damages of $350,000. The Trial Smelter decision set an important precedent in international environmental law on two counts. First, it established the transboundary pollution damages. Second, the legal principles of the trial smelter decision were recognized at the Stockholm Conference on the Human Environment in the year 1972. The award of the arbitral tribunal in the trial smelter case is frequently cited to support the view that general principles of international law impose obligations on states to prevent transboundary air pollution. This dispute arose out of damage done to crops, pasture land, trees and agriculture in the United States from sulfur dioxide emissions from a smelting plant at the Consolidated Mining and Smelting Company of Canada at trial. In British Columbia, emissions and damage had increased significantly after 1906 and again after 1925 and 1927, leading to the submission of the issue to the US-Canada International Joint Commission established under the 1909 Boundary Waters Treaty. In February 1931, the Commission adopted a unanimous report awarding the United States US $350,000 to compensate for damages suffered in the period up to January 1932. In April 1935, the two countries signed a convention submitting the dispute to an arbitral tribunal composed of 3 arbitrators, assisted by 2 scientists designated respectively by the two countries, and stated, under the principle of international law, no state has the right to use or permit the use of territory in such a manner as to cause injury by fumes in or to the territory of another or the properties or persons therein, when the case is of serious consequences and the injury is established by clear and convincing evidence. The tribunal in the trial smelter case found that the smelter at trial in Canada had caused damage in the United States. The tribunal was called upon to decide what indemnity should be paid for the damage. As to any damage occurring after 1st October 1940, irrespective of compliance with the regime it had established, the tribunal held that an indemnity should be paid for such damage when as if the two governments arranged for the settlement of claims under Article 11 of the Convention, as well as up to US $7,500 per year to be paid to the United States as compensation in order to ascertain whether damage had occurred, provided that the two governments had determined under Article 11 of the Convention the damage had occurred in the year in question. The next important case is Torrey Canyon disaster, United Kingdom, 1967 incident. After the Torrey Canyon disaster, the United Nations General Assembly gave increased attention to the protection of the marine environment, and in 1969 it adopted a resolution promoting effective measures for the prevention and control of marine pollution. This is called on the United Nations to prepare reports for the 1972 Stockholm Conference to review harmful substances and ways which might affect human health and activities, which are marine environment and coastal area, and national and international activities for prevention and control of marine pollution, and also make suggestions for comprehensive action and improved international coordination. Many interrelated conventions and protocols were developed in response to individual oil pollution incidents, beginning in the year 1969 with the Torrey Canyon accident, which resulted in the escape of 1,17,000 tons of crude oil in the western approaches to the United Kingdom, this causing extensive damage to the British coast and to the coast of France. The ship was registered under the flag of Liberia, and the accident occurred outside the territorial sea of the United Kingdom, raising the question of whether the coastal state should intervene to address a pollution incident occurring in areas beyond national jurisdiction. This led to the Brussels Conference of 1969 and the adoption of the 1969 Intervention Convention. Torrey Canyon, which ran aground in the Atlantic off the southwest coast of Britain on 18 March 1967, while carrying nearly 1,20,000 tons of crude oil, the escape oil caused widespread damage to the British coastline and to marine life, and eventually polluted the coast of France. The accident led to the Brussels Conference of 1969 and the adoption of two new conventions, the 1969 Intervention Convention and the 1969 Civil Liability Convention. The Civil Liability Convention has been the subject of three amending protocols: the 1992 Liability Protocol, with the entry into force of the 1992 Protocol. The 1969 Civil Liability Convention is now known as the International Convention on Civil Liability for Oil Pollution Damage 1992. Another landmark case is Lac Lennox case in the year 1957, 12 RIAA 281 24 ILR 101. This arbitral award in the Lac Lennox case is in between France and Spain. This concerned a proposal by the French government to authorize the construction of a barrage to channel water through a hydroelectric power plant, diverting approximately 25% of the flow of the Carrel River before returning the same amount of water to the river at a point prior to its use by farmers in Spain. The arbitral tribunal held that the proposed French works did not constitute an infringement of Spain's rights under earlier treaties, although the tribunal did suggest that the Spanish claim to an infringement of rights might have been stronger if it could have shown, which it had not, that the proposed works would pollute the waters of the river Carrel or change the chemical composition, the temperature or other characteristics of the water in such a way as to injure its interest. The award considered whether riparian states have any obligation to notify and consult with others who may be potentially affected prior to engaging in activities which may harm a shared river resource. The tribunal held that France is entitled to exercise her rights she cannot ignore. Spanish interests. Spain is entitled to demand that her rights be respected and that her interests be taken into consideration. In the Lac Lennox case, the arbitral tribunal held that France had a duty to consult with Spain certain projects likely to affect its interests, and that in this context the reality of the obligations thus undertaken is incontestable and sanctions can be applied in the event. For example, of an unjustified breaking off by the discussions, abnormal delays, disregard of the agreed procedures, systematic refusals to take into consideration adverse proposals of interest, and more generally in case of violation of the rules of good faith. Another important case is the Corfu Channel case, ICJ 1949, ICJ 422. In this case, a principle was established that the state should not knowingly allow their territory to be used for acts contrary to the rights of other states, and from this can be deduced also a duty to inform other states of known environmental hazards. Article 198 of the United Nations Convention on the Law of the Sea provides that when a state becomes aware of cases in which the marine environment is in imminent danger of being damaged or has been damaged by pollution, it shall immediately notify the other states it deems likely to be affected by such damage, as well as other competent international authorities. Now, to conclude, the international legal order regulates the activities of international community comprising of states, international organizations and non-state actors. States have the primary role in the international legal order as both international lawmakers and holders of international rights and obligations. Under international law, states are sovereign and exercise equal rights and duties as members of the international community in protecting the environment. State responsibility covers many fields which include omissions or commissions of unlawful acts directly committed by one state and affecting other states. Judicial activism in combating the transboundary pollution hazards has created a new environmental jurisprudence at international level. It is pertinent to submit that the approach of the courts and the tribunals in the case cited is aimed at protecting and controlling the environmental pollution in transboundary areas by invoking the responsibility of the states at international level. There are transboundary pollution problems which require immediate attention. Hence, there is a mutual obligation and collective responsibility on the part of the states to promote the effective control of transboundary issues and hazardous waste management. Dear students, this would be the end of pollution related chapters in the subject of environmental law. Next chapter, I will be dealing with the human rights and environment. I hope you have enjoyed this session. Thank you.